So one of the things that employers sometimes ask is, well, what do we do if the employee hasn't returned to work? They've come back, we know they're off orders, and they just abandon their job. Can we fire them? If an employee isn't returning back to work, start the process that you would use for any other employee who was non-reporting, who was absent without leave from the workplace. The critical point here to USERRA is that USERRA offers some greater protections in certain areas of the law, but no less protections. So treat them like you would any other employee who hasn't shown up to work. If you have a policy that after 3 days of no call, no show, then they're terminated, then that's the policy you follow. Don't make it any harder for a service member, because then we start getting back to section 4311, which is the discrimination issue, and you could be seen discriminating against them. Say you gave all the other employees 5 AWOLs, and then you fire them, and the first day the service member doesn't show up after coming back. You fire them. I'm sure you all can see how that could be construed as discrimination, probably because it is. And there's one final one after the 5th point we need to discuss, and that's the disabled employee. Now, the disabled employee has up to 2 years to return to the workplace. It allows time for convalescence, to transition back, and allow them to return to the workplace. And there's this disabled employee is in a unique position. The disabled employee under USERRA is treated much differently than a disabled employee is treated under the Americans with Disabilities Act. Now, we could go on for a day talking about the Americans with Disabilities Act. The critical issue here is that a disabled employee under USERRA can have an accommodation upon the return to the workplace. And that accommodation might not put them back into the same position they held before they left. It depends on the nature of the disability. But generally, it allows for them to be placed somewhere in the workplace. Can it mean a job with less pay, with less duties, with less responsibilities? If that's what fits their disability, yes, it can. The theory here is that VA benefits will then make up for the portion of pay that has been reduced. Again, this is a tricky area of the law. If you are a disabled service member, or if you are an employer or somebody concerned, you'll need to do more research in this area. You're probably going to need to consult a disability advocate or an attorney to resolve this issue. It's very tricky and can involve tremendous liability for an employer who gets it wrong. Now, if the service member has met those 5 criteria, there's the question of where does the employee get placed when they return from military service? Now, if they've been gone a month or less, it's pretty easy. They go back to where they were. Same job, no changes. If the employee's been gone more than a month, though, it gets a little more interesting. An employer is not required to hold a job open indefinitely. They can put temporary employees into that position while the service member is gone. And if they've been gone more than a month, they have to be put into a substantially similar position. Essentially, the same job, maybe a little different. Not maybe the same exact job, but the same type of job. Similar responsibilities, similar opportunities, similar pay, similar status. You get the picture. The critical thing to remember here, and you see it all over the USERRA literature, is one key thought. And that thought is that the employee should return to where they would have been as if they never left. The concept here is called the escalator. That an employee gets on an escalator with a group of similar employees, and they ride that escalator up with that same group of employees. Service members right in there with all their colleagues. Service member gets off the escalator, goes to Iraq, Afghanistan, somewhere. When they come back, they're with those other employees. Wages, benefits, opportunities, status, all that. They go right back there. Now, if this is a unionized workplace and there's a collective bargaining agreement, that's real easy. Seniority, rates of pay are in the agreement. If not, follow the escalator. Now, in a constricting economy like we've had for the past 5 years, that escalator can go down. Say there's been massive layoffs. So long as they're not laying people off just because they're a service member, people can get laid off while they're deployed. Again, we go back to the anti-discrimination portions that I mentioned at the beginning of this discussion. As long as they're part of that whole group, if everybody on that escalator got laid off, well, service member, sorry, you're getting laid off too. If their pay has been reduced, that pay is going to get reduced. And we are seeing some of that in a bad economy. A couple other issues here. The key one is promotion. What about the promotional exam that goes on when the employees are gone? Well, the military has proctors. If you have a promotional exam, you can contact the military and they might be able to have somebody come out and give that exam under exam conditions where it's sealed, mailed back, fine. Some companies send proctors to certain military installations, like in Germany, for example, where people can take the test. You can offer the test, however, you cannot require a deployed service member to take the test. They've got other things to do. If they want to, they can. And when they come back, they need to be afforded the same opportunity that everybody got. That includes materials, study time, anything else that the workplace offers. So the employee comes back to where they would have been as if they never left. If there's a promotion, they're offered the opportunity for promotion, and they get a couple of other things. There are no insurance restrictions. Once that employee reports back to work, they're back on the insurance plan. There's no waiting periods or anything, and that's under a couple of different federal laws besides just USERRA. So somebody can't come back from Afghanistan and you tell them, oh, I'm sorry, you've got to wait 30 days before you're on the plan. They're back on the plan. I mentioned in the beginning a little bit of history, and I think we should conclude with a little bit of history. After the collapse of the Eastern Bloc, the National Guard and Reserve Forces had much more reliance placed on them because active duty was drawn down in huge numbers. And we saw those Guard and Reserve units activated in the Gulf War. We saw them activated in Iraq and Afghanistan and everywhere else since September 11th. That's not going to change. The Department of Defense leaders have testified in front of Congress that the National Guard and Reserve members are the most cost-effective soldiers. They get much more work out of these personnel for the same amount of money than for active duty. And the National Guard specifically has transitioned from being a strategic reserve, oh, maybe we'll send them if it's really important, to an operational reserve. So it's no longer a question of if they're going to go, it's a question of when they're going to go. That's what our current citizen soldiers are facing. That's what employers need to understand. Hopefully this presentation has given you a general overview of USERRA, the prohibitions against discrimination in the workplace, and the re-employment rights that are available to the service member. Thank you.